Good morning, this is your Kelso Report for Tuesday, May 1st. I'm your host, Clark Kelso. Today we have cases dealing with criminal sentencing, sex crimes, meal and rest periods, commercial leases, and franchise agreements. We begin with the Ninth Circuit in a case involving criminal sentencing issues. The defendant in United States v. Dorsey participated in a conspiracy to traffic in stolen vehicles. And when a grand jury was poised to lower the boom, tried to intimidate one of the witnesses by taking a couple of shots at the witness through the witness's kitchen window. Well, the defendant ultimately pled guilty to 20 counts related to the stolen vehicles and was convicted of witness tampering and using a gun in connection with witness tampering. The defendant challenged on appeal the admission of testimony from two witnesses who said they saw the defendant with a Glock before the shooting took place, near where the shooting took place. Relevant testimony, obviously, because the bullets and casings at the scene were identified as being consistent with a Glock, and because the defendant clearly had lied about an alleged alibi, claiming he was across town at the time of the shooting, when cell phone records showed that he was but a few blocks from where the shooting occurred. The Ninth Circuit affirmed the admission of the testimony. The defendant also objected to a statement made by one of the police officers who, during cross-examination by defense counsel, said that the defendant, quote, did it, close quote. Well, the court immediately instructed the jury to disregard and denied a mistrial motion, and the Ninth Circuit agreed that the testimony was harmless, and indeed might actually have harmed the prosecution, since the defense theory of the case was that the police had blinders on from the start and had focused only on the defendant. Finally, the Ninth Circuit held that the maximum term for a conviction of discharging a firearm in relation to a crime of violence is a life term, since the statute specifies only a, quote, term of imprisonment of not less than 10 years, close quote, and does not specify a maximum. The court rejected application of the rule of lenity because it was clear that Congress intended that offenses for discharging firearms are to be punished severely. And severely it was punished. Next, the California Supreme Court will begin with a sex crimes case. In People v. Cornett, the California Supreme Court answered the question, what does it mean to be 10 years of age? The question arose in the context of a prosecution under Penal Code Section 288.7, which makes it a felony punishable by an indeterminate life term for any adult to engage in specified sexual conduct, quote, with a child who is 10 years of age or younger, close quote. The Court of Appeal held that this language means the child must have been molested prior to the day of or on the day of the child's 10th birthday. But the California Supreme Court reversed, holding that the statutory phrase 10 years of age or younger includes children younger than 10 years of age and children who have reached their 10th birthday, but who have not yet reached their 11th birthday. In other words, 10 years of age or younger is synonymous with under 11 years of age. As the court explained, in common parlance, a person reaches a particular age on the anniversary of his or her birth and remains that age until reaching the next anniversary of his or her birth. And absent any particular legislative history, one way or the other, the Supreme Court stuck with the ordinary meaning of the phrase. Next, attorney's fees. As a general matter, a prevailing party may recover attorney's fees only when a statute or fee-shifting agreement so provides. Well, in Kirby v. Immoose Fire Protection, the California Supreme Court considered the question of whether any statute provided for attorney's fees in the context of a claim for missed meal and rest periods under Section 226.7 of the Labor Code. The two relevant provisions here were sections 1194 and 218.5 of the Labor Code. Section 1194 provides fees only for prevailing employees in actions for legal minimum wage or legal overtime compensation. Well, the court held that neither the plain text nor the history of Section 1194 supported an interpretation that would encompass claims for the non-provision of statutorily mandated rest and meal period. Similarly, Section 218.5 of the Labor Code provides for attorney's fees to the prevailing party in an action brought for the non-payment of wages, except in those cases governed by Section 1194. Well, as with its interpretation of Section 1194, the Supreme Court held that Section 218.5 does not cover a claim for missed meal and rest periods. Accordingly, there is no statute which authorizes attorney's fees in the context of a missed meal and rest period claim, and the Supreme Court therefore reversed the award of attorney's fees to the defendant, who had prevailed below on the merits and been awarded fees by both the trial court and the Court of Appeal. Now, this may be a result that will quickly draw the attention of the California legislature, which I would suspect would be inclined to expand the employee-only attorney fee provision in Section 1194 to include claims for missed meal and rest periods. Seems odd that they would have left a gap for that particular type of claim. Next, an interpretation of a commercial lease. Courts generally disfavor perpetuities. Just makes them uncomfortable. But despite being disfavored, courts will enforce a lease provision that grants a tenant the right to unlimited renewals so long as the parties intend to create that right and the intent is explicit and clear. If there is any uncertainty in that regard, the lease will be construed as establishing only one right to renewal. In Ginsburg v. Gabson, the Second District held that the commercial lease before it was not sufficiently clear, and so it gave the tenant only one option to extend. The lease provided that, quote, tenant shall have the option to extend the term of the lease for additional 5-year periods upon the same terms and conditions contained in the lease except as hereafter stated, close quote. Now, this language does not expressly say the power to extend the lease shall operate without limit, so the court rejected that interpretation. The court also reversed the Superior Court's finding of punitive damages for breach of the covenant of quiet enjoyment, noting that the covenant is a contract term. The breach of that covenant is generally viewed as a contract claim, and punitive damages are, of course, not available for mere breaches of contract. Finally, we have a case involving franchise agreements. The plaintiff, who owned several McDonald's franchises, sought a preliminary injunction to permit him to continue operating 3 McDonald's restaurants in Marin County, pending completion of a trial before the court on other issues. The trial court granted the preliminary injunction and McDonald's appealed, in part on the ground that its franchise agreements should be interpreted as personal services contracts and, as such, should not be subject to preliminary injunctive relief. In Hussein v. McDonald's Corporation, the First District held that the McDonald's franchise agreement was not a personal services contract. McDonald's itself recognized that their franchise agreements were not really personal services by arguing in another context in the case that there is a robust commercial market for their franchises, and the identity of particular franchisees is not nearly as important as particular agreements on the ability of a franchisee to implement the franchise agreement. Well, that's it for today's Kelso Report. Have a great day in the law.